send it to you?
Yes, please.
Okay, I will.
Are you sending it in email?
I will. It is. Everything is okay. Good morning, everyone. We may be starting a few minutes later. Our 10:30 speaker, Mr. Gessner, is not here, but I'm hoping he's on his way, and I'm looking for him right now. going to try to send it to Zuber real quick. Thank you. Our speaker, there he is. All right. Zuber, I think we're ready to go. Hey, Randy, you'll need to go ahead and
Hi. Is it possible to move that so I can put mine?
Yeah, so I'm not
Oh, sorry.
the PowerPoint.
No, I don't need to hook it up. I just need to be able to look at it. So if I can put it on top, is fine. Perfect, thank you. Please.
Thank you, everyone, and welcome back to iStand 2020. Thank you for those who are tuning into the live stream for your patience. We are ready for our second plenary session, Repatriating America's Stolen Children. It is our honor and our pleasure to introduce to you Jared Ginsner. Drawing upon his 7 years of experience representing and advocating for left-behind parents, Jared will discuss the difficulties of securing a child's return under the Hague Convention procedures and what can be done to make them more effective. He will also discuss the U.S. State Department's response to international parental child abduction and why it's been frustrating and ineffective for left-behind parents, with two specific examples. First, the State Department has failed to make use of the Goldman Act, which authorizes it to impose escalating series of penalties on countries that refuse to cooperate on IPCA cases. Second, the State Department consistently refuses to waive the personal appearance requirement for abducted children who need a new passport. Even when this requirement is impossible to meet and the issuance of the passport is the only barrier to securing the return, the safe and legal return of the child. Mr. Gessner will also highlight a legislative fix in the latter problem that will soon be introduced in Congress. Jared Gessner, welcome.
Well, thank you, everyone, and it's great to be here with you all. My apologies for being a little delayed. I guess I'm not used to actually getting dressed up and going out to conferences, and unfortunately it took a little longer than I would have liked to find parking. Well, look, it's a pleasure to be here with all of you this morning, on the one hand. On the other hand, you all are here because I know there are a lot of left-behind parents, survivors of parental child abduction, and many, many others, and who care about this issue. And it's devastating and tragic that we have to keep having these kinds of discussions and meetings and, talking about the kinds of things that need to be done because, frankly, the United States government, in my view, has absolutely and utterly failed to protect America's children from being abducted abroad. So in my time this morning, and I'll leave a lot of time for questions, I want to talk about a couple different things. I want to talk, as was noted before, a little bit about the failure of the U.S. to engage in the kinds of activities that would help protect America's children and return them to the United States, and what more can be done there. And then I also want to talk about a narrow issue, which may have impacted a number of you, which is especially challenging for left-behind parents, and I've helped a number of families through this, which relates to the question of trying to recover your child and what happens when you're simply trying to get a passport for your own child when your child has been abducted, and how difficult it is for left-behind parents to obtain simply a passport that might enable them to even, in many cases, legally recover their own children. And I'll give some examples of that as well. As was noted, I've worked on a wide array of cases of left-behind parents, always on the side of the left-behind parent. I have not once nor would I ever represent an abductor to try to justify the abduction of a child under any circumstance. As we all know well, parental child abduction is child abuse, and I will never under any circumstance stand on the side of an abuser. We also know very well the horrors that left-behind parents face when, after your child has been abducted, you are then accused of a wide array of bogus allegations to try to ex post facto justify the abduction, and claim that it was somehow justified simply because you're trying to protect your own child. To me, this is just an egregious, simply an egregious miscarriage of justice, and to stand in the way of a loving child having access to a loving parent is really about the worst kind of abuse I can imagine inflicting on a child. So, one of the biggest challenges that we've had over many, many years has been getting the State Department to actually do more than just simply track cases. I think that we have all had our challenges dealing with the Office of Children's Issues at the State Department over time. Many of the people who work there are well-meaning, but ultimately they are powerless, and oftentimes, well, they're not well-meaning, and say or explain how they really are trying to help, when in fact they're really seeming to come up with another set of excuses as to why they actually are not going to help. And so, this is why, of course, Congressman Smith, Chris Smith in particular, adopted the Goldman Act, proposed and ultimately secured the adoption of the Goldman Act with support from obviously the U.S. Senate as well. And, the whole purpose of the Goldman Act was to create a new set of tools for the State Department to be able to employ when trying to compel countries around the world to return children who have been abducted, clearly in violation of the Hague Convention, or in cases where a country is not a party to the Hague Convention, in cases where the children were clearly abducted and should be returned under common law principles to the loving parents who had custody of the child. And, in theory, and this was more than 5 years ago, the Goldman Act lists 8 potential sets of actions that can be taken against governments that fail to comply with their obligations under the Hague Convention. And they include things such as a démarche, an official public statement detailing unresolved cases, public condemnation, a delay or cancellation of one or more working official or state visits, the withdrawal, limitation, or suspension of U.S. development assistance, the withdrawal, limitation, or suspension of security assistance, the withdrawal, limitation, or suspension of other kinds of foreign assistance from the Economic Support Fund, and a formal request from a country to extradite an individual engaged in an abduction who has been formally accused of, charged with, or convicted of an extraditable offense. And as of at this stage, as best as I can tell, really only the first 3 of these basic actions, a démarche, an official public statement, or public condemnation, are really the only measures that the State Department has been willing to employ, and they are all toothless measures that, in my view, unfortunately don't have the kind of impact that is necessary in cases to compel states to take action. But one of the issues that I've been, and I want to talk about a few of these, my experience with a few of these related questions and my attempts to secure these for left-behind parents, because I think that it's one thing to speak in general terms about the law, what the law says, what the law authorizes, but the reality is I think what we all care about is how does this actually help an actual abducted child be reunited with their left-behind parent, right? And at the end of the day, if there are reunifications happening, then then one can clearly say some things are being done well, and if they're not happening, you can conclude they're not being done well. And I think that it's self-evident when you look at the returns to the United States and you talk to people on children's issues and you anecdotally get to know lots of left-behind parents, that virtually all of the returns are with mutual cooperation of the abductor, right? There are very, very few returns that are against the will of the abductor. And this, of course, underlines and underscores the enormous challenges with implementation of the Goldman Act. I worked on a very high-profile case, and I continue to work on a high-profile case that's been in the public domain, and so obviously I'm not revealing any attorney-client privilege because of what I'm describing has been publicly reported. but I represent Chris Brand of Texas, whose son was abducted to Brazil in 2015, and has been gone for 5 years. And that case was about as clear a set of facts as you could ever imagine for a case, and a textbook case of a parent trying to do the best that he could. There was a travel agreement in place, actually, in that case, where Chris Brand was aware of David Goldman's struggle to get his son Sean home from Brazil. His wife is Brazilian, and the soon-to-be ex-wife, they were in the middle of a divorce, was going to Brazil for her brother's wedding and wanted to bring their son with them. And so they actually executed a travel agreement filed with the court. It was Marcela Guimarães who had filed the petition for divorce in Texas in the first place, and she was an American citizen, dual national, and they got married in Texas. Their whole life was in Texas. Nico had never spent a day in Brazil other than on a vacation. It turns out she was premeditating the abduction of her son. Literally within 3 days of arriving, they filed a case in a local court in Brazil and were awarded sole custody within 10 days, something that's, shall we say, highly irregular for what should happen in Brazil. The family it's well known that the family is, the Guimarães family is exceptionally wealthy and successful. It's really unexplained how this was possible. But even when Chris, was able to finally learn about what had happened a month or two later and realized then his ex-wife to be was not coming home, the local court refused to reconsider the case. Ultimately in that case, you had kind of a surprising set of things happen. And one was the government of Brazil actually took Chris Brand's side. They did a full analysis of the case before the Brazilian Central Authority, the Office of the Attorney General. They had their own independent psychologist look at the situation, and they concluded that Nico was abducted and he must be immediately returned to the United States. And in fact, they joined the litigation on Chris's side in Brazil and have been a part of that litigation on our side for 5 years. Again, to no avail, because the courts in Brazil don't want to return left behind kids to the United States. That case got even more profile when, in working with the FBI, we were ultimately able to secure initially a sealed indictment against the ex-wife and her parents who would help facilitate the abduction, and in demonstrable ways, paying for the plane tickets, sustaining her in Brazil, lying to Chris, claiming that she was coming back when they knew she wasn't, and these kinds of things. And to our surprise, the parents came to the United States to visit Chris's ex-brother-in-law, who had lived in the U.S. with his wife, and they were arrested, and ultimately detained, and then released on bail, and then put on trial, and then convicted, and given, unfortunately, very, very lenient sentences for international parental child abduction. We're still trying to get Marcela Guimarães extradited to the United States, which would obviously change the dynamic enormously in regards to their case. And it is possible to extradite a Brazilian national to the U.S. In a narrow set of circumstances. Actually, Brazil won't extradite a Brazilian national alone, someone with only Brazilian citizenship. But if you, under the Brazilian Constitution, interestingly, if you take on a foreign nationality, as Ms. Guimarães did, then you actually have been deemed under the Constitution to have surrendered your Brazilian nationality, and therefore you can be denaturalized and then extradited as an American to the United States. And this is something we've been working on for 2 years, and the Justice Department, as far as we can tell, although they keep saying they're working on it, has yet to get any forward motion on the case. And this is a case that should have the perfect set of facts to try to be able to achieve success. And you all know the story of the way foreign courts and foreign governments often deal with these things, which in Chris Brand's case, again, manufactured evidence of domestic abuse allegations, none of which he raised in Texas. The ex-wife claims that Chris pushed her down the stairs when she was pregnant. Never once mentioned that in a year of litigation in a U.S. court. And by the way, in the United States, they had joint custody by mutual consent. She never challenged his right to joint custody. And so these are the kinds of things, unfortunately, that happen. And the interesting thing to me, and the issue that I keep pushing on with regards to the State Department's inaction, is that they're actually, the Goldman Act creates 8 options for what one can do with a country like Brazil that's persistently non-compliant, like Japan, like India, et cetera. And yet there are plenty of other things that the U.S. has authority to do, which could force the return of American children to the United States. And we're not even willing to do things that are also just already within legal authority. So one of the issues I've raised with the Assistant Secretary for Consular Affairs, Secretary Risch, is, he has the authority to decide where visa officers are placed in embassies around the world and what visas they're willing to process and what their target rates are for how quickly those rates get processed. So one of the things that I suggested that they do in a case like Brazil, is simply tell the government of Brazil, until our abducted kids are returned, we're going to scale back processing of visas. You can start by stopping the processing of visitor visas. Obviously, with COVID right now, this is a moot point for the time being in light of the small number of visas being processed. But the world, we hope and pray, will return soon enough. And if we just say, we're not going to process a single tourist visa, or visitor visa, non-immigrant, visitor visa, which would enable, for example, a Brazilian to visit family that they might have in the United States, until you return our abducted kids, I suspect they would find a way to return our abducted kids. It's very simple, right? And so, I'm not suggesting we call it H-1B visas, business visas, because of course then we'd have the whole business lobby against us, the Chamber of Commerce and everything else. But when you're talking about processing of visitor visas, or student visas, you can go after whatever you'd like. My view is that would compel the return. You don't even have to invoke any of the parts of the Goldman Act, and Risch has complete discretion to decide how to allocate his resources of all of his consular staff around the world. And he can just say, well, not only are we not going to process it, but if you keep this up, we're going to just reassign these officers and relocate them to other countries. And so we're now just going to permanently cut the consular staff in Brazil. Again, other bilateral issues, always seem to be more important than bringing home our abducted children. So let me now turn to the second issue that I wanted to discuss today, because I've been in the weeds on that issue for a while now, and I'm excited to report that one way or another we're going to find some progress on this. And this is the issue of left-behind parents recovering their kids legally, and the obstacles that are thrown up by the State Department to stand in the way of that. And I have several different India cases right now that I'm working on, which is ultimately what prompted the need for a global fix to this issue. And so first, let me tell you a happy story. We have lots of sad ones, but it's important to relish and enjoy the happy ones. I was representing a woman whose name I won't share, whose ex-husband abducted their son to India from the United States. And in that case, she had all the court orders in place in the U.S. for sole custody, that were put in place after the abduction. They'd had joint custody at the time. The court order itself, in the state court order said, that the child cannot be taken to another country that is not a party to the Hague Convention, without the explicit written permission of the court. And, then the ex-husband goes to visit family in India and then doesn't come back. And so, again, another very, very clear-cut case from a domestic law perspective. And I ended up learning about this case and getting involved in the case because of a narrow problem that this woman in the U.S. was having, the left-behind parent, which was the following. Interestingly, India, some of you may know, actually doesn't even have a crime of parental child abduction. That in and of itself is kind of stunning and egregious, but nonetheless, that's the reality. And so that reality actually is a potentially positive thing for a left-behind parent trying to recover a child from India. Obviously, the negative thing is they're not a part of the Hague Convention, but the positive thing is you can go and legally obtain custody of your child if there isn't a court order in place that provides sole custody to the parent in India. And because the Indian courts are so egregiously slow, and even though they ultimately will really always prevail on the side of the abductor, because it just takes years to even get that first court order of sole custody for a parent who abducted their child to India, you actually have time to actually go recover your child. So, in this particular case, we had privately succeeded in getting an indictment issued against the father who was the abductor, and the FBI was very, very helpful, in this process as well. And having talked to our to my client's local counsel. I was able to confirm that there was no court order of sole custody in favor of the father, that he'd been trying to get it, but it was dragging on and on and on. And the father, who had been a very abusive spouse in the United States, which is why, they ended up getting divorced, and why, my client didn't want to be with this gentleman anymore. Continued to be abusive from abroad, controlling access to the child, but he would provide semi-regular access to the child, both on the phone and ultimately in person. And so literally one day, and this obviously is a scary thing for any left behind parent to do, but in the context of what happens in a country like India and the law that says there's no parental child, or the lack of a law that says, that demonstrates there's no parental child abduction, she literally just, knowing that he had left his home, and knowing that the only person that was home was, the abductor's mom and housekeeper, she knocked on the front door. Her child came to the front door, saw her there. They'd been separated for a year and a half, only seeing each other rarely. He was so happy to see her, he runs and jumps into her arms, and she goes and gets in a car and drives away. The mother tried to, the ex-mother-in-law tried to run after them, but the reality is, and they later tried to manufacture criminal charges against my client, claiming that somehow, because she fell running after him, that was the responsibility of the mom. And of course, the mother-in-law had no legal authority under Indian law or any law to actually be the caregiver. So it's sort of like, the bank robber trying to blame, the bank guard for being shot. If you're part of or facilitating a crime and you get injured in the process, tough luck for you. And ultimately, we worked out in advance getting a passport for this woman, but it took 6 months to get an American passport for her child, who only, by the way, had American citizenship and was literally stateless. The child was left stateless because his passport had expired, and he was an illegal migrant in India. And even though he could be sent to jail, and India is doing that now with children who are illegal migrants, the State Department was refusing repeatedly to give a passport. And so we got a bunch of members of Congress involved and beat the hell out of the State Department. Ultimately, we were able to get the passport, and she was then able to ultimately cross the border on a bus from India to Nepal, and then get a flight back to the United States. And so this young boy, Jay, is now safely back here with her, with his mom, and this again is, I think, a positive outcome. But I've got two other clients right now in India that have been struggling for now multiple years to get the passports for their kids, and the facts of their cases are even more egregious. And so, in the very few minutes I've left here right now, I wanted to just tell you about the law around this question of how you get your passport. You're supposed to be able to get a passport, a single parent consent passport with a waiver of personal appearance, what the problems are, and then what the legislative fix is that we're working on. In short, the way that it works to get a passport for your minor child is that basically you're required to show up with both parents at either a U.S. passport agency or abroad at a consulate, and jointly request the passport, and then the child is supposed to be physically presented in person. We all know that this is, of course, impossible in the case of left behind parents. Not to be the master of the obvious, but this general rule, which I don't disagree with as a general proposition, in general this makes sense, obviously makes no sense at all in the case of left behind parents in these kinds of terrible circumstances. And so, I think what's particularly problematic about this is that the standard for the waiver of personal appearance, number one, is very vague, and number two, seems to not even be interpreted by its plain language, but always seems to be interpreted against the left behind parent. So you can get the requirement of the two parents showing up waived very easily, in the sense that if you have a court order from the United States that says you have sole custody, then ultimately that's all you need to get a waiver of the two-parent presentation requirement. But on the issue of waiver of personal appearance, there's a part of the Foreign Affairs Manual that says, which the State Department is supposed to use as guidance, which provides that Personal appearance may be waived if personal appearance would jeopardize the minor's health, safety, or welfare, or cause other compelling hardship. Now, you would think that an abduction should qualify for such a waiver. Last I checked, abduction is child abuse, and the only court order that exists in the entire world that was valid would be the court order from the United States, which almost always, not always, but quite regularly precedes any potential foreign court proceedings. And so, in having multiple engagements with the State Department on this, what ultimately you learn is that interpretation of that provision, which should clearly, in my view, include parental child abduction as something that's a danger to the child's health, safety, and welfare, especially I would note in cases where the child doesn't have a passport, where they're solely an American citizen, where the lack of the passport, like in India, renders them an illegal migrant, where they can't access health care or education without a national identity card, which you can only get if you're a citizen of India. And so in those circumstances, the danger to the health and welfare of the child could be profound and severe, of getting imprisoned, of not having access to health care, of not having access to education. And what they've said to me repeatedly is, we interpret this provision to mean that the physical presentation of the child itself at the embassy constitutes a danger to their health, safety, or welfare. In other words, and the examples they gave me, and this is rather ironic in light of what's happened in our national history in the last 9 months, is this was, and I had a meeting in December of 2019 with one of my clients whose child was abducted to India, and this is the argument that was made by the Office of Children's Issues. And, they said, well, the cases that we've seen that typically qualify for these waivers are cases where the child, for example, has a compromised immune system, and so sitting in a waiting room could expose the child to getting sick and potentially even dying because of the compromised immune system, or situations of a war zone, and they actually said, or in the situation of a pandemic. This was in December of 2019. And so as the pandemic hit, we went back to the State Department, and they wouldn't give us a straight answer, and of course never have given my client, that client in particular, his passport and for his child, so he could recover his child. And their claim was, well, the guy in question had told an actual member of Congress that engaged with him, well, I made a mistake by referring to pandemics. And yet to me, you would think that the pandemic, where for a long time in India, the country was on a national lockdown, and it was therefore illegal to go out for any reason, which would mean that if my client was able to get to India and took his son to the embassy, they could be pulled over by the police, which would be a high likelihood given that there was a stay-at-home order in place for an extended period of time. And once it was discovered the child didn't have an Indian identity card and didn't have a valid passport, the child would be arrested for being an illegal migrant and then taken to a migrant's prison. And yet that wasn't sufficient for the State Department. So clearly this, this issue of the waiver of personal appearance needs a dramatic fix. It could be as fixed as easily as simply changing the Foreign Affairs Manual, which doesn't require a change in law. But in essence, the people that we've dealt with at the State Department in various bureaus, Children's Issues, in the Secretary of State's office, in Legal Advisor's office, and the Human Rights Bureau, have basically all told us, our hands are tied. There's no need for them to be tied. Again, Secretary Pompeo could just direct a change in the Foreign Affairs Manual to fix the problem. And so it became clear to me that a legislative fix was necessary. And so we've been working with several members of Congress on a legislative fix. And the hope is that, this will prompt the State Department to do the right thing, and that we don't have to go through the bill through the Congress to get signed by the President into law. It wouldn't ever be a standalone bill, but it would be attached onto like a foreign affairs appropriations bill or otherwise. So let me just very briefly walk you through this and then kind of come to a conclusion with some final remarks. In essence, what the bill did, and the bill has been entitled, in light of the current president, Putting Abducted American Kids First Act of 2020. And there's a series of findings in the draft bill that talks about such things as, the act of abducting and taking to a foreign country by the parent of a minor without the consent of the other parent is illegal under federal and state law. It mentions the Hague Convention, and the purpose is to protect children internationally from the harmful effects of their wrongful removal or retention. It quotes from the Hague Convention and talks about how central authorities in other countries are required to take all appropriate measures to provide, and in the U.S., to take administrative arrangements as may be necessary to secure the return of a child, which would, of course, include issuing of a passport. Even the Foreign Affairs Manual itself, when talking about IPCA cases, says the U.S. policy is that a child, who has been a habitual resident of the U.S. and wrongfully removed or retained outside the country should be promptly returned to the United States, and ultimately the State Department is supposed to engage in these kinds of cases to try to help facilitate the return of kids. The reality is, of course, that a abducted American kid cannot return to the United States to their habitual residence unless they actually have a passport that enables them to travel across international borders. In terms of the actual fix itself, this is this is the text that we really came up with, and in particular, it's basically a new provision of law that would amend the section relating to passport issuance in the U.S. Code, and it says that under a section entitled "No Requirement for Abducted Minor to Personally Appear for Passport Issuance Purposes," and it says, notwithstanding any other provision of law, the Secretary of State may not require an abducted minor to personally appear for passport issuance purposes if the left-behind parent of the minor, 1, files a complaint with the Office of Children's Issues of the State Department alleging the abduction of the minor falls under the standards of the Hague Convention, 2, is the parent applying for the passport, and 3, presents the Department of State a valid U.S. court order from a court of competent jurisdiction that A, grants the left-behind parent sole legal custody or its legal equivalent, B, finds the minor has been abducted, and C, orders the return of the abducted minor to the United States. And then it also directs from there that the Foreign Affairs Manual must be updated to include this new standard. Now, one concern that people have had about this language is that it could be more narrow than one might like, in the sense that, obviously a court order of sole custody is necessary, but requiring the court to have concluded the child has been abducted, the minor has been abducted, and ordering the child's return is not something ordinarily, or not something that always happens in the cases of IPCA cases. Ultimately, in discussions with people on Capitol Hill, and in light of the need to try to move this legislation through, if at all possible, basically I sought as much as possible to remove any potential objections that could arise about the efficacy and the legitimacy of imposing this kind of requirement on the State Department to not act and require the presentation of a minor. And so, given the State Department is going to strongly oppose this provision, I'm sure, we wanted to take away as many arguments as we could from them as to why it wasn't, in fact, a bad idea. But the thing to me that I find particularly egregious and outrageous and frustrating, especially in dealing with this administration, as it relates to IPCA cases, is that I'm really not aware of much of anything that they've been doing to advance the return of abducted American kids, despite claiming that, America is first and Americans are first. I don't see what could be more important than bringing home abducted American kids to anybody's agenda. The number of ways they've tied themselves up in knots on this particular provision and stood in the way of the lawful return of children is really outrageous. I mean, I've got this. So where we're going to go from here, I don't want to kind of speak publicly about the names of the members of Congress involved in advance of them announcing the bill. But one of my left-behind parents from India is preparing right now to go public with his whole story. He's been at this for years unsuccessfully. He's, as I think you all appreciate, at the end of his rope with the State Department and his enormous and extraordinary frustration at their inability to be of any assistance here. And so he's going to come out publicly and tell his story very soon. And he's going to say, in essence, President Trump, you say you care about our abducted America, you talk about America first and Americans first. What about my son? My son's an American. He's an illegal migrant in India right now. He could be arrested at any time. He can't access education or health care because he doesn't have a national ID card. And your administration decided, and there's no, by the way, no court order of custody in his case that gives custody to the mother. She's been fighting to get that, but in her case, actually, she originally had gotten such an order by lying about and withholding from the court all the information that had happened actually in California in that case. And actually the court reversed an order of custody and went all the way up to the Supreme Court and is now back down to the family court with no order in place. So, right now, if simply he had a passport, he could recover his son legally in the same way that my other client did. And yet, because he can't get a passport for his son, it's not possible, his daughter, it's not possible for him to be able to do that. So, the irony here as well is that, and I've made these arguments to Trump administration officials unsuccessfully, and I'm really an advocate. I'm not a political person by nature. All the work I do is nonpartisan on these kinds of cases. But the argument I've been making to Trump administration officials is that you say the Constitution is paramount. You say you believe in originalist thinking and originalist application of the Constitution to U.S. law. Well, our Constitution says very clearly that, the Congress only has powers that are enumerated in the Constitution, and that any issues not addressed or discussed in the Constitution are reserved for the states. And states' rights is a big mantra of conservatives in their views of the Constitution. And yet in this case, it's worse than just leaving an American child who's been abducted abroad and subjected to child abuse on a daily basis, in a regular situation where they could also even be arrested and sent to jail. But here, the position of the State Department is to functionally block the implementation of the only valid court order that applies to this child. And so you have the federal government bigfooting the states and saying that the state court order of sole custody can be ignored, and blocking the return of the child that has to be done. These court orders, as you know, typically demand the immediate return of the child to the United States. So by what conservative interpretation of the Constitution and U.S. law is it okay for the federal government to trample on the rights of states, when family law has never been and is not a enumerated power of the Constitution for the Congress or the President in the Constitution, and regulating family law is not part of it. And so, by what conservative legal interpretation is it appropriate for the State Department to functionally block the implementation of a valid U.S. court order? Again, haven't gotten a great answer to that question, but we are talking to. There's a conservative think tank that's well known. Again, I'm not going to reveal things in advance of them coming out publicly, but is also working on this issue with us now, and they're going to come out with their own views about this question and this issue. And because of the think tank it comes from and the credibility of the person in particular working on this, I think that will undoubtedly all that will get in front of every conservative Republican member of Congress, and it will be viewed by people in the administration because it will be a friendly fire, set of questions being raised about, this person and this think tank doesn't think that this kind of a policy is consistent with what America First is supposed to be about. It's not consistent with conservative interpretations of the Constitution, and it's not, most importantly, advancing the interests of our kids. So let me leave it at that. I know I've covered a lot of ground. I'm happy to obviously answer questions and engage in further discussion. Again, my apologies for being a little bit late. I hope it was worth the wait. Again, happy to answer any questions.
Thank you so much. My imagination is fired with some new ideas and new lines of inquiry for advancing it. So I certainly have some questions, but defer to the audience. Mr. Tolan, Paul Tolan.
Yeah, hi, Paul Tolan here. So one comment and then a question. The comment is on the actual State Department. You don't have to wonder why they're doing what they're doing, as long as you start with the premise that their relations with foreign countries always override our children. Their children are not famous children, they're not important children. And I've told Bishop this many times. There are exceptions like David Goldman and the return there when the high level publicity was creating enough bad press
So,
This is the stuff I was working before I disengaged in 2015, but I mean, there was other, obviously there's people that didn't even know what was going on and why that didn't happen.
so one of the challenges for Congressman Smith, and I am about as big a fan of Congressman Smith as anyone could be, super fan, is the changeover in the control of the House from Republican to Democrat. And that was a very big factor.
He had 2 years. He had from the inauguration of 2017 until the election at the end until 2019 when the Democrats took over. He had 2 years of a Republican senator.
Yeah.
Republican president. Was there resistance in the Senate? Was he figuring it would be hopeless to get? I mean, where was the resistance? Why didn't they get done?
Yeah. So I mean, I've had similar conversations. Yeah, I've had similar conversations with Congressman Smith about the need to go to a next phase of the Goldman Act in light of the fact that the act itself is not being utilized.
Did you acknowledge that before the act?
Yeah, of course.
Well,
Yeah.
This is phase one. I'm going to do this just like I did human trafficking. 3 phases, each one stronger than the last. Preferably, I'm going to advance to the next phase when I've got a friendly Senate, House, and White House, and he had that for 2 years. I just don't know if anybody was working on it.
So I didn't work on that in particular, but I do know that when it comes to additional legislation that would replicate the trafficking bill or the international religious freedom bill that requires reports, that rates countries, that imposes automatic consequences, et cetera, that there's undoubtedly enormous resistance from the State Department on those bills in the first place, as well as strong political resistance from institutionalists in the Congress, including from the Republican Party, who feel that there have been too many of those kinds of new regimes set up. I obviously couldn't agree more with you that one needs to be set up on this issue, and I can't speak specifically what Congressman Smith, may or may not have been thinking, but I can say that I know for a fact from many years working in Washington that, after a number of these different bills were passed that created these whole reporting mechanisms and structures, there wasn't a huge appetite in the Congress to do much more with this, and sadly, this administration, and really every administration, doesn't seem to care about our abducted kids all that much and be willing to put it as a priority. There's always a handful of people in any administration that do care and are fighting the system to try to do that, but ultimately not in a high enough position.
I'm guessing it was the State Department that probably kept it forward, but I don't know.
Microphone for other questions.
Hi, John Stefanik. Oh, cool. My question is more toward your earlier comments. No one here is going to disagree that parental abduction is both child abuse and domestic violence. But as far as I know, like parental alienation and abduction aren't even listed in the DSM-5 for therapists as child abuse. So how do you bridge that gap to child abuse in a legal sense?
So, I'm not a family lawyer. I know enough to be dangerous, but not a family lawyer. And I think ultimately, the way that I would describe it is the following. I mean, there are, the U.S. Supreme Court in one of its prior cases specifically talked about the dramatic negative impact on children of parental-child abduction, as you probably know. And so that's a precedent applicable to the United States. In fact, I've got it right here, so let me just quickly pull that up for you, because I think it's important to do that. But in essence, one of the things that we've done on this, on the issue of the waiver of personal appearance question, is to put together a detailed memo for the State Department, which I'm happy to share privately with any of you. I'd ask you not to make it public. There's no identifying information of my clients, but it provides a very good analysis for the State Department as to all the reasons why we're arguing that they should make the change to the Foreign Affairs Manual or to members of Congress for supporting the bill. But so, in the case of Abbott versus Abbott from 2010, this is what the Supreme Court itself said in the majority opinion, by Justice Kennedy. An abduction can have devastating consequences for a child. Some child psychologists believe that the trauma children suffer from these abductions is one of the worst forms of child abuse. A child abducted by one parent is separated from the second parent and the child support system. Studies have shown that separation by abduction can cause psychological problems ranging from depression and acute stress disorder to post-traumatic stress disorder and identity formation issues. A child abducted at an earlier age can experience loss of community stability, leading to loneliness, anger, and fear of abandonment. Abductions may prevent the child from forming a relationship with the left-behind parent. impairing the child's ability to mature. Obviously, it doesn't directly address parental alienation, which is the question you asked, but it obviously refers to parental alienation in terms of the obstacles to forming a relationship with the left-behind parent. And so, and the State Department itself has said, abducted children are at risk of serious emotional and psychological problems. Research shows that recovered children often experience a range of problems, including anxiety, eating problems, nightmare mood swings, sleep disturbances, aggressive behavior, resentment, guilt, and fearfulness. And so, from my perspective, we don't need to prove, for the purposes of advocating in the U.S., that parental child abduction is child abuse, because the U.S. Supreme Court has said it is, for all practical purposes. So is the U.S. State Department, so is the U.S. Congress in the preambulatory language to the Goldman Act. And I think undoubtedly you're correct that the DSM-5 or the DSM-6 will need to address this issue. And I think the reality is it hasn't gotten the attention that it deserves, because although there are parental alienation, in many cases they're not just simply in cases of abductions, which are kind of the most extreme version of bad things that can happen. It happens a lot in divorce. But I do think there's a growing body of academic literature on the question. But there candidly isn't enough studies that would enable one to have the underlying medical support, psychological support for adding a new section in the DSM. But undoubtedly, this isn't. I've talked to a number of psychologists about this. My sister also happens to be a child psychologist who specializes in the issue of child trauma, primarily child sexual and physical abuse. But undoubtedly, this is something that needs to obtain greater attention. I mean, sadly, in many of my cases, it hasn't been a problem it hasn't been a problem for people in various countries that I've worked in to consider parental alienation as one of the factors that should be considered about child abuse. In fact, in all the countries I've worked in, which is about half a dozen countries, the local psychologist, so-called local expert, has considered parental alienation, but then dismissed it, claiming that the alienation was really the fault of the left-behind parent who had, and they wrongly concluded that the spouse had been abused or these kinds of things. So what's interesting to me is, at least based on my experience, is that there isn't a disagreement around parental alienation being a key factor to look at when it comes to the psychological welfare of the child. They just, in extraordinary and shocking and stunning ways, aren't willing to consider it applying in the case of a parental child abduction, which makes no sense at all, psychologically speaking. I mean, and to me, it's sort of extraordinary to me how many of these expert reports I've seen over the years where, a psychologist in a foreign country doesn't consider the fact that grabbing a kid and taking them out of the only environment they've ever known, where they don't even speak the local language in many cases, where they have no friends, where they've never lived, might have a severely disrupting effect on the child from a psychological perspective. In Brazil, on my Brazil case, it was especially egregious because of the gender discrimination against my client, who was a man. And basically, the conclusion of the psychologist is that it's in the best interest of the child to remain with the mother because he has a close relationship with the mother. And then later on, we had one of the courts in Chris Brand's case actually say that, it would be an outrage to return a child to a selfish American parent like my client who works, and has a job, and therefore wouldn't be able to spend full time with the child, even though the ex-wife in Brazil also works and doesn't spend all the time with the child. So, again, you kind of, how this all goes. But it's a good question and a challenging one, I think. But I think that's definitely an area that more work needs to be done.
You mentioned that that parental abduction is not a crime in India, and one of your clients was able to go and simply retrieve the child because it isn't a crime. And now, well, I do understand the sort of reasoning that they are doing. I was wondering if you experienced any backlash from the Indian government or from the police, because while I have seen places where they claim that parental kidnapping is not a crime, a bunch of different countries, not naming any names, but a lot of things. But amazingly, it suddenly becomes a crime if the American parent goes there to retrieve their kid.
It's a great question. And On the one, so obviously everything is case specific. So
I'm talking in a broad sense.
yeah. Let me tell you what happened in India, and then try to speak more broadly to it. Undoubtedly, you're right. I mean, ultimately, countries that don't comply with the Hague Convention will come up with whatever legal excuse they can if a child, even if a child is recovered legally, to then try to falsify or create some kind of set of crimes against the parent. The reality is that the United States is not going to indict or prosecute an American parent of an American child, or not a foreign parent of an American child who was living in the U.S.
No, I wasn't thinking about it in the sense of the American thing, but
Yeah.
in the sense of the country there.
Yeah. So in the India case I was working on, the father, as often seems to be the case in these situations, was well connected. His lawyer was a former Attorney General of India. They went ballistic, as you might imagine, lodging a police report and all these kinds of things, and lodging urgent complaints in the Indian legal system, et cetera. And, we all know the power dynamics that exist when a child is abducted, and the very, enormous amount of inertia that's created to not upset the status quo, even though the status quo was created by a brazenly and flagrant illegal act of a parental child abduction. And interestingly, in India, ultimately, despite all the bluster from the father and his lawyer and all these kinds of things, ultimately the case got dismissed in the Supreme Court of India, saying we no longer have jurisdiction over the child's in the United States, and the criminal charges that were being pushed, end up getting dropped, and ultimately the father in India lost all of his leverage. Because the Indian courts basically at that stage basically concluded, while we might have been able to hold on to the kid for quite a while, now the kid is in the U.S., do we want to take on the United States by issuing countervailing court orders when the child is back in the U.S. given the pre-existing court order? And their calculus changed, which was a surprise. I think that wasn't something that I would have anticipated. But I think undoubtedly I'm not here, just to be clear, to encourage left-behind parents to go and recover their abducted kids. The only way to do that is to do it the right way, to do it in consultation with local counsel, to make sure you understand the laws of a country before you were to engage in that kind of activity. Yeah.
They publicized it in this particular small country, like immediately, like it was a stranger abduction, failing to mention that the child had just been taken by a parent who who was supposed to have access custody of the child. They'd been kidnapped, and they put out half the police force in this place, and eventually found them. The parent got arrested, and they were kicked out, and you could never come back. And of course, since they couldn't come back, they couldn't go to any sort of hearings, so they lost all of them. And and it's just one of those situations where I was sort of surprised the police or whatever in India did not actually try that.
Yeah, I think because she was able to get out quickly, and that was obviously the plan. I was not able to advise her in any of these cases. I can't advise a client about what the requirements of local law. So I'm not involved in myself personally facilitating the exfiltration. I can describe what the U.S. government would do and how it will respond based on my own experience. But ultimately, these are very scary and risky operations and things that, again, one has to think very, very carefully about, especially if you're dealing with a country where there is a custody order in place in favor of the abductor. It becomes much more dicey, and
It's not something I actually do either.
no, neither would I.
Against the wall enough times, I sort of can see why it might seem like a more appealing option.
I mean, ultimately, people come to a point, as you all know well, better than me, where the desperation overrides the judgment that one might make about the risk. If it's a choice between having a chance at getting your child back versus never able to see your child during the child's youth, I don't envy any of you or any left-behind parent in having to make that kind of incredibly horrible and difficult and painful decision. Ultimately, this shouldn't be an issue, and I think at the end of the day, the bottom line is that we need the U.S. government to do what's necessary to bring our abducted kids home. And you don't just need the Golden Act, as I said. There are plenty of other things the U.S. could do if it just simply exercised if it just simply exercised its discretion within the framework of existing law. And so I think we need much more. And I want to congratulate Noelle, who of course has lived through this herself, and what she's done since to create iStand and to provide a place for solidarity and support for left behind parents and for abducted kids to be able to come together regularly to talk about these kinds of questions and issues, to advocate with the U.S. government for the kind of policies that are necessary. This kind of work is invaluable, and frankly, it's the only reason why the Goldman Act exists in the first place is because of left behind parents like many of you, and ultimately, much more needs to be done. But as I said, I've been at this now for many years, and as a parent myself, of actually a divorced parent whose ex-wife is Canadian. When I was going through my whole divorce process, I was thinking to myself, as you might imagine, what would happen if my ex-wife took my kids to Canada? And of course, Canada is not India or Brazil, but nonetheless, and my ex-wife has never been and is not the kind of person who you think would do this. But nonetheless, you have to think about it. I mean, in light of one's own experience. And so I think, again, I want to compliment Noelle and iStand for all your really, really critically important work. And I'm always a ready partner and happy to help wherever I can to force the U.S. government to take these issues more seriously.
Thank you. I do have a question, and then we have time for one more, perhaps before our awards luncheon. You mentioned your anticipation that the State Department is going to vigorously and rigorously oppose this proposed legislation. We absolutely know that is how they work, and at various times throughout the time that our coalition has been advocating on Capitol Hill for this issue, we've had a few opportunities where we've had friendly legislators to help us introduce legislation, which we supported. And then here comes the State Department, and they have a precise and calculated way of squashing legislation. So what is your strategy for that anticipated response?
So you're absolutely right, and we've all lived through this on these kinds of questions and trying to get legislation introduced. I think the primary thing is to put a human face on what's going on here in the name of my client, who you'll learn about publicly shortly, and what he's gone through, and just how outrageous it is. Because he couldn't have a better set of facts to get a passport. Literally for his son. No court order in place. No, he's only an American citizen. No Indian identity card. At risk of being arrested for being a migrant and denied access to education and health care. In the middle of a pandemic, where there was a lockdown for a long period of time, and it remains very, very difficult and dangerous to come to the U.S. Embassy, and where the U.S. Embassy actually is not processing ordinarily, for example, visitor visas or other things right now at all for people coming from India, and where there's no law against parental-child abduction. That is an ideal test case for this proposition, and so the first and most important thing will be having a human face on this to be able to tell this story. And part of him telling the story and me telling the story will also be about how this is a flagrant betrayal of this administration's claimed conservative credentials in the way in which it is quashing a valid state court order. So that's one key part. The other, just very quickly, just to conclude, the other parts is working with this conservative think tank and to get support from the conservative side of the aisle, from thinkers about the injustice of all this, and having that kind of support will make it harder for Pompeo and for the State Department to oppose this. And then, lastly, just of course we have to be relentless. I think that's pretty much, as you all know better than me, the only way that we can get our kids home. So.
I'd like to make one other point about what you just said. And so most of you in this audience do not know this, and certainly those who are tuning in live. And so I'm actually speaking to the president. So over the last week, a request was made for the parents in this community, which is very diverse and certainly represents America's precious asset in our children. 3 times in 3 different ways, a request went to the President of the United States to meet with this group of parents. It came from the United States Senate Majority Leader Mitch McConnell from his office. It came from the campaign manager for the Trump campaign. And I know it came from at least one other source, which I also cannot say. And so I appreciate you saying and then restating again that America First must mean America First for America's stolen children. And I agree with you, and I'm pleased to see that you are having these conversations, which it sounds like it's going to be productive and bear fruit with a conservative think tank, and letting the rhetoric match up with the ambition. And so, Mr. President, we do say to you that there is a group of Americans who have American children who were kidnapped abroad, and we know that you have the impetus, we hope that you have the impetus and the power to do so. Mr. Garrett, thank you so much, Mr. Ginser, for joining us today. We do have a gift for you because we're in these times.
Yes.
We'd like to present an iStand mask to you. And this is our 7th anniversary, and so we have a commemorative pin for you.
Very nice.
Thank you so much.
Thank you.
Thank you.